Good afternoon to everyone. Welcome to this training on training lawyers to defend victims of SLAPPs. This is organized by the Additives Foundation in collaboration with the Maltese Chamber of Advocates and is part of the PATFox project, which is co-funded by the European Union. The PATFox project aims at addressing training at lawyers and other legal professionals working across the European Union. And just as this training is taking place in Malta, there are similar projects taking place in other EU member states, which are part of the project. I'll round up quickly the agenda so that we'll have an idea of what's going to be happening this afternoon. So the training today will be divided into three sections, and the first section will be handled by myself. I'm Dr. Zammit Maempel. I'll introduce myself in a short while. After that, we'll move into a second part of the training, which is the international dimension of SLAPPs. So we'll be looking at the proposed anti-EU SLAPP directive and the private international law dimension of SLAPPs. This will be handled by Professor Justin Borge-Partey and Dr. Erin Ferguson from the University of Aberdeen. They will be joining us remotely. And lastly, we will move into a panel discussion. I've invited three guests over here today, Dr. Therese Comedini Kakia, Dr. Joe Zammit Maempel, and Ms. Martina Uso. And together we will be holding a discussion with them based more on the practical day-to-day handling of the legal situation and of SLAPPs here in Malta on a day-to-day basis. Before going further, I'll introduce myself quickly. So I'm Dr. Michael Zammit. Some of you already know me. I've been working in media and free expression law since the days I became a lawyer way back in 2001. I've advised a number of media houses in Malta, I still do. And I've also handled free expression cases, including cases that have been decided by the European Court of Human Rights in Strasbourg, particularly dealing with censorship in the arts, particularly. So free expression and journalism and media are very much my uh, key subjects. I've always been passionate about them, and this is why Additives Foundation approached me and asked me to handle this training and to organize it on their behalf. Let's dive right in. So, we're here today to talk about the Maltese situation with regards to SLAPPs. So, what I want to go throughout the next minutes of our presentation here is, first of all, to assess the current situation here in Malta. What's going on? What laws do we have that are working or not working? How is Maltese law shaping up to deal with the challenge that SLAPPs have brought on in more recent years? And lastly, I also want to look forward slightly to the future to see how things may develop from there. This last point, what the future will hold, will be developed further, particularly by my colleagues Justin and Erin Ferguson, who, as I said, will be tackling the proposed EU directive on the subject. Before we really get into the meat of things, let's talk about some basics. And I think a definition is perhaps useful at this point before we talk of anything else. So SLAPP is an acronym. It's an acronym that means Strategic Lawsuit Against Public Participation. What does that mean? It means that the aim of a SLAPP suit is typically that of burdening critics with legal defense costs to censor, intimidate, and silence them. So here we're looking at a lawsuit which outwardly looks entirely normal, has followed all the rules of procedure, has followed all the rules of the book, if you want. What distinguishes it from normal, legitimate, morally justified action is the motivation. And the motivation behind a SLAPP suit is typically that of censoring, intimidating, or silencing a critic. So it's with this definition that we launch into this presentation and we discuss how SLAPPs work in Malta and abroad and what can be done to deal with them. All right, so as I've just mentioned in the previous slide, we are talking here of a lawsuit where we're looking primarily at the motivation driving that lawsuit and not so much the outward appearance of that lawsuit, the formality of that lawsuit, that tends to take a second place when we are looking at SLAPPs. Now, why are SLAPPs a concern in Malta? They're a concern because of a number of reasons, and perhaps the name of Daphne Caruana Galizia will crop up more than once during this training session today. Not so much because of the political or particularly polarized views that there are on Daphne Caruana Galizia and what she wrote and what she did, but more so because it is a stark case where a lot of the examples, a lot of the cases that we now define as SLAPPs first came to light during the time when she was being sued. We all know that at the time of her death, she had approximately 40 suits pending against her, which were, the majority of which were largely incendiary cases. They were not entirely out to seek a redress of justice in the moral sense, but they were there to harass her, and harass her they did. So we've seen how here in Malta, slap suits can be used as a tool to silence critics and to stifle free speech. Whether they actually were effective in regards to Daphne is, of course, a questionable matter. But certainly, Daphne is not the only person in regards to whom these suits were proposed. So just as Daphne, ultimately bore the ultimate brunt of them, there are many journalists today which are constantly on the receiving end of slap threats, if not actually suits themselves. Now, this leads to a second effect, and people like me who work with journalists will tell you how frequently we come across journalists who hold back from publishing stories, from investigating stories, or from digging and looking up more information that could be of huge public interest, but they tend to press the brakes on what they are doing because of a fear, if you want, a fear of consequences, a fear of retribution, a fear of being made to be dragged to court and find oneself the subject of a lawsuit that may drag on for ages, may cost money. You may not be guaranteed the full backing of your employers. So altogether, this produces what we call the chilling effect. And the chilling effect is precisely this, that it pours freezing water over what should be a hot and bubbling industry, which is that of the press. So by the mere threat, the mere knowledge that you could be hit by this sort of action, even if you're not actually hit with this action, but that produces a counter effect towards free speech. One of the key problems we have in Malta as well is the lack of specific anti-SLAPP legislation. So whereas we have general defences in our law and general provisions, which we will be discussing later, we don't have specific anti-SLAPP legislation. So our tools with dealing with SLAPP are, as I said, they arise through generic laws and they are therefore of a generic nature rather than of a very specific and very targeted nature. Let's talk more about the kind of suits that we are looking at, the kind of actions that we are looking at when we contemplate SLAPPs. Now, they can take different forms, but there are three areas where laws are typically used or abused in this sense. The classic area that immediately comes to mind when we are talking about SLAPPs are press and media laws, including libel defamation laws. Now, this would imply people filing a libel action when they claim that their reputation or their good standing in the eye of the public has been tarnished or somehow damaged. So what do? They file a libel suit against the journalist or against the media publishing house, and they ask for redress in that sense. However, there are two other areas of laws which are seeing an increasing number of abusive suits or abusive appeals sprout their heads. The second area is the freedom of information laws. Freedom of information, as you know, is a law introduced fairly recently in Malta, whereby individuals, citizens, journalists primarily, have the right to request information of any government department, any government entity, or any government controlled company. Which they feel could be in the public interest. But the right is, although it is set in the law as being available to any person who has resided in Malta for 5 years or more, in reality, this is an effective tool for journalists to access information which may not be immediately forthcoming. So it's a way to ask for instance, consultancy contracts of people who may be suspected of being overpaid or of breaching financial procurement laws. It may be a way of discovering contracts that may, at their nature, have a corrupt basis. Freedom of information laws are an effective tool in holding public entities to account. The last section of laws that are typically used for SLAPP suits are data protection laws. And an example I'll give you of this is when you have individuals who write threatening letters to journalists and ask them not to keep information, not to look up information in their regard, on the basis that this breaches their right to privacy. There are, of course, general provisions in the GDPR and in other laws which pretty much give a blanket provision to journalistic activity and allow journalists to use information if they feel it is in the public interest and feel that it may lead to a story that may have public interest in that sense. So by signaling these threats to journalists early on, again, we're moving back to what we said before. So we're going back to the chilling effect in journalism. So those are the three main areas of law that typically meet SLAPPs. This isn't to say that there aren't other areas of law that are affected by SLAPPs. I mean, technically, one could think of an ordinary civil suit as also having as its motivation that of intimidating, censoring, or somehow burdening critics with extra costs and extra litigation hassles, let's call them. But obviously, they were encompassing the entire body of law. So, for the sake of focus, let us look at these three areas of laws as being areas of primary concern. As I said before, so local experience has shown that many FOI requests, freedom of information requests, are currently being denied without basis, and appeals are similarly filed without sufficient basis. I think the best example we have of this is that concerning the Shift News, the media house known as the Shift News, which is currently facing something around 40 appeals. The context of this is that the Shift requested information on one particular government consultant and asked for copies of all contracts, of all consultancy and outsourcing contracts that had been awarded to this individual, and was soon met with 40 appeals filed by various government entities and departments, all rejecting or refusing to provide this information despite an order by the Information and Data Protection Commissioner who ordered them to do so. So, one appeal is one thing, but having to fight 40 has led to a situation where the Shift has had to turn to crowdfunding. Fortunately, it managed to raise the money through crowdfunding, but nonetheless, it is a huge financial burden. Excuse me, a huge financial burden that it will need to face. As I mentioned before as well in the earlier slide, so data privacy is also being used as a pretext on which to threaten journalists not to dig or not to publish. And there are some lawyers over here who will understand me when I talk about journalists who we meet on a day-to-day basis, who often show us copies of these letters, and they are truly threatening. They do. I completely see why journalists would think twice about going ahead with this sort of activity. Let's start looking at a closer, let's give a closer look to some of the laws that we have in Malta. So, Chapter 579 of the Laws of Malta, which is the Media and Defamation Act, was introduced in 2018. Now, the context over here is that it took place a year after Daphne's assassination. So that gives it a little bit of context of why it was brought in at the time it was brought in. Now, it was modeled extremely closely on the English Defamation Act of 2013. In the meantime, the English Act has been amended as lately as August 2022. However, the Maltese Act has not been updated since 2018. So we, as a model, it looks more closely at the original English 2013 Act than it does the updated version. Now, one of the plus points of these laws, both laws, is that they introduce a single publication rule, which protects against repeated or continuous publications on the internet. So, what does this mean? It means that in an age where an article is published online and may be picked up by another news source and republished in its entirety, or picked up by Reddit, or picked up by Facebook, whatever it is, and may be published repeatedly and over a long period of time. So this has prevented journalists from being sued multiple times every time someone clicks a forward or republish button. So we now look only at the first moment of publication, and that is the single instance on which journalists may be sued if obviously there is anything defamatory or libelous contained in that article. So this has protected journalists in a positive way against multiple and repeated lawsuits. I'm going to take a moment just to raise one point that arises from the Defamation Act 2013, the English and Welsh Act. So one of the key problems that has arisen over here is that the English Act, allows a person not domiciled in the UK to bring action against any defendant if they can show that England and Wales are clearly the most appropriate places in which to bring an action in respect of the statement. So I will give you an example. We could have, for instance, a Russian oligarch who feels libeled by an article written in Malta or published on an online news portal here in Malta. However, if that Russian oligarch can claim that most of his business interests, most of his investments, most of his trade, most of his daily life, if you wish, maybe he's moved to London and taken a place in Mayfair. But if he can show that England or London are the most appropriate places in which to bring an action because of his link to England and Wales, then he can sue the Maltese journalist who wrote that article on a tiny Maltese portal here in Malta. He can use the courts of England and Wales as the forum in which to bring these actions. Now, why is this particularly relevant for Malta? And the key answer over here is our language. Given that the Maltese journalistic sphere is heavily biased in favor of the English language in the sense that most of our journalism takes place in English. So our journalism does take place in Maltese as well, but we are kind of used to having more investigative journalism take place in English rather than in Maltese. This exposes journalists working in Malta to a higher degree of scrutiny. Why? Because if an article were written in Maltese, it would perhaps be clearer that the audience is intended to be a rather tiny population of 500,000 people, largely based on an island in the Mediterranean, which are the only people who speak the language in the world, practically. Whereas if you are writing in English, it is far easier for that article to be picked up abroad, English being a global language. So the fact that our colonial history has made English the language that it is here in Malta today has pushed us onto a language stage, if I can call it that, which is unequal to what, let's say, a Portuguese or a Greek or a Romanian journalist would find themselves on in other countries. So what's going on in the Defamation Act in England and Wales is relevant to us because it has this carry-on effect, if you wish, here in Malta. Let's look more closely at the Media Defamation Act here in Malta and look at some of the provisions that it has, weak as they are, but which offer some sort of preliminary way of filtering out lawsuits which may be manifestly frivolous. And one of the measures that was introduced in the 2018 Act to counter this element of abuse was that of the preliminary hearing. So these days, when you file a libel suit in Malta before the Court of Magistrates, so you are guaranteed a first hearing within 20 days from the deadline for filing defence pleas. So to sum up that timeline, you would have the action filed. It would go to the magistrate's chambers and a date would be appointed. From the moment the writs are sent out and notified, there is a 20-day period for the defendant to file defence pleas. Once those 20 days are up, then the 20 days mentioned on my slide would start running. So this gives libel lawsuits in Malta a rather quick a quick trip from the moment that they are filed until the moment that they are first heard. Unlike other lawsuits, which, as we all know, due to certain backlogs that the Maltese courts tend to rack up, can often take a significant amount of time to be heard and eventually decided. So there's a somewhat fast track for libel suits to be heard. The reason I mention this, obviously, is because if you have a frivolous or SLAPP suit on your hands, obviously what you want to do is get rid of this as soon as possible. So the fact that you have this fast track to appointment is obviously a plus point. Once the court takes cognizance of the case and holds the first hearing, it may at that point send parties to mediation or give time for an agreement to reach or for an apology to be made. This will take place only in those cases where the damages do not exceed €1,000. So in Malta, we have a capping of damages that is between 12 and €13,000. So if we're talking about the minor cases where there's a basis where the parties can sit around the table, hammer out an agreement, come to a settlement, then the court will, if you wish, force them to go down this avenue and not to come back before it until they've hammered out such a solution. In reality, this method is used quite often by the Maltese courts, and the magistrate, I use the singular because the Maltese courts use a system where cases are assigned on a subject basis to individual magistrates who then tend to specialize in them. So the current magistrate who is hearing the large number of libel cases does use this measure very often. How successful is it? That's another question. It often depends on the parties and on the level of, shall we say, animosity, shall we say, pique that exists between the parties. On occasion, there have been ways and occasions where such settlement has been reached. On others, it hasn't. One of the most recent cases I've had ended in this way in November, where the parties decided to make a settlement after they were forced to go to mediation. But by far, it is the exception, not the rule. Let's talk about general defences existing in Maltese law as a whole. So, Maltese law allows defendants to file a motion to dismiss. This is usually done through the defence pleas, which are filed at the moment when the defendant needs to file those defence pleas. So you may file a defence plea or a motion to dismiss the case on the grounds that the suit lacks merit. In practice, the court will almost always proceed to hear the merits of the case before it throws out cases on a preliminary basis. And it does this because experience has shown that when it does kick out cases at a very early stage, an appeal is typically filed immediately. So it tends to replicate the work rather than make lighter work of it. So the court will, although the defense exists in theory, in reality it is one that is rarely used because it sometimes can be counterproductive for the workload of the court. The second general defense, not so much contained in our law, but um, one that develops from practice, is that early intervention can avoid unnecessary legal fees and limit damage. What do I mean by this? I mean that advising clients at a very early stage when they receive the first warning of a threat or the first indication that something something may be problematic, and intervening with advice and offering remedies at that stage before things get too litigious and then get to court often stops the case in its tracks at an earlier stage rather than when it's become too expensive and too heated up to stop it at that point. So, if journalists come to us as lawyers at an earlier stage, it's often more helpful than when they come to us waiving writs that they received by notification. There are the general defenses of arguing that the lawsuit was brought with the primary intent to silence or punish defendant for exercising their right to free speech. This could possibly result in a referral to the Constitutional Court if it has to decide the case of free expression. Again, here I'm talking of a defense which, although it exists on paper, I can think of hardly any occasions where it has been used. Why? Because the court will typically want to hear the whole case before it decides on whether there has been any abuse or not. At a stretch, there is also the option of filing a counterclaim for abuse of process. So if your client, if a journalist has been hit with a libel suit, which is clearly a slap in nature, there is the option of filing a counterclaim and claiming damages for the abuse of the process. To my knowledge, this has not occurred to date. But it would be interesting to see if anyone would take this line of defense or this line of action in the future, possibly the near future as well. So, insofar as general defenses are concerned, you've seen that they are somewhat vague and they are somewhat, I don't want to use the word dead letter, but they aren't exactly the most effective of defenses, shall we say. They create problems in real life, in practice, when it comes to actually applying them. There are, of course, other ways that we can look at this, and where any sort of threat, any sort of slap threat, is accompanied either with threats of harm, or if the threats are carried out by means of electronic communication, so are conducted by email or conducted over social media or any electronic system, there could be a basis to file a police report. In the first case, when we're talking about threats of harm, there would be the general provisions of the criminal code which tackle threats of harm in the general sense. But there are also the more specialized offenses, which we call the offenses of computer misuse, where if a threat is carried out by means of electronic communications, then the offense is taken far more seriously and the penalties are far heftier. So if a journalist feels this sort of intimidation, feels this sort of threat, one of the options available to them is to file a police report in this sense. We've noticed in recent times that the police tend to take these reports somewhat more seriously than they used to 5, 6 years ago. Again, the Daphne effect has made them a little bit more conscious of what could happen if they do not react at all to these sort of reports. So they do tend to look at them. They are still a little bit slow sometimes in acting upon them, but at least they do look at them and they do follow up those that are worthy of being followed up. Another defense, again, doesn't arise from the law, but is an effective means of addressing slaps, is by attacking slaps on one of their key weaknesses. So slaps often thrive on a culture of silence and fear. We mentioned the chilling effect before, that stories may be discontinued or suppressed and never make it to publication because of the fear that journalists feel in that sense. Sometimes journalists or those working in the media will also receive letters, legal letters marked confidential and using lots of grand language, warning the receiver not to make the matter public, even though there's no legal basis for this. So the way of countering this is precisely to publicize the threats or the litigation and bringing media attention to the case. This is usually beneficial because it forces the claimant to deal with negative publicity. So the last thing that someone, if you're bullying someone in silence, the last thing you want is a spotlight thrown onto you, because this suddenly makes you look like the bad guy. And apart from dealing with the original claim that may have been included in that journalist's work, suddenly you're met with the opprobrium of public opinion, which is often stronger than whatever lawsuit or whatever um, article or investigation may have been carried out in your regard. So using public opinion, using publicity, using media attention can be effective in demonstrating that the suit is frivolous and intended to censor or intimidate. Because if after bringing media attention to what is going on, someone actually proceeds with that lawsuit, they are you could bring the argument that they are proving your point in being abusive purely because they have been warned not to in the court of public opinion. What is the role of the court when it comes to SLAPP litigation? So the court plays a crucial role in protecting individuals from SLAPP litigation. So the fact that it is empowered or will be empowered once specific laws are in place to dismiss such cases early on and awarding to cost to the defendant if the case is found to be frivolous, it is obviously key to creating a bit of a deterrent effect. Maltese law allows courts to award the penalty of double costs. So if a case is dismissed and is found to be frivolous or vexatious or so lacking in merit that it is clear that it's only being done for harassment purposes, the Maltese courts are allowed to award the plaintiff, sorry, to award the defendant double costs to be paid by the plaintiff on the basis of this frivolity. Education and awareness work in both ways. So it's important both for our judiciary to be skilled and educated in recognizing SLAPPs for what they are and recognizing the wider role that SLAPPs have in free expression in the Fourth Estate generally. As much as it is lawyers who have an important role in educating clients about SLAPP litigation and what available defense strategies are available to deal with these threats. Just as we are doing today, there's the importance for raising awareness within the legal community and general public about the need for anti-SLAPP legislation in Malta. And to do this, it's not only the case of using Daphne Caruana Galizia as some sort of performing monkey just to say, look what's happened, but to show the very real effects of what happens when you have SLAPP suits that are allowed to go ahead unhindered, and they do result in someone's assassination. Which is not to say necessarily that she was assassinated directly by the people who filed those libel suits, but the fact that they created an atmosphere where it was acceptable or there was nothing to eyebrow raising about the fact that a woman was on the receiving end of 40 libel suits creates an atmosphere where if you wish, anything goes. And that anything goes could lead to violence, could lead to assassinations. Daphne is, of course, not unique in this. So we've seen other journalists across Europe. I'm thinking of Jan Kuciak in Slovakia, who have also been on the receiving end of horrific violence and assassination purely because of their journalistic work. So let's round up what we've been saying so far. So SLAPP litigation can be a powerful tool to silence critics, and stifle free speech. So as I said, we distinguish a SLAPP suit because of this motivation. Malta currently lacks specific anti-SLAPP legislation, meaning the system is somewhat vulnerable and open for exploitation. Will this be addressed by the proposed EU directive? That remains to be seen. We've also discussed how there are general defenses and some strategies to defend clients against SLAPP suits. I'll move on to talking about some case studies that we have with regards to SLAPP in Malta. I mentioned some of these earlier, but it's worth bringing some of them up. The cases involving the shift news are somewhat interesting for those of you who wish to look them up. Some of them are in the process of being decided in the next few weeks, if not the next few months. And it is worth seeing how these will be held up or whether they will again go through another round of appeals before perhaps the Constitutional Court, depending on the way that the Appeals Tribunal for the Information and Data Protection cases will look at the cases. So far, we don't have a judgment over there on any of the 40 appeals, but as I said, we are waiting for these to take place in the next few weeks. The other case that I wish to bring to your attention was the DB cases, we call them. So again, I'm going to refer to Daphne Caruana Galizia over here. Daphne Caruana Galizia was hit on the same day with 19 libel cases, all filed by Silvio De Bono of the DB Group. The DB Group, as you know, own a number of hotels and catering establishments across Malta. And the basis for this was that she had written one or two articles, and Mr. De Bono, instead of filing one lawsuit grouping all of these allegations in one lawsuit, instead opted to take each sentence separately, each phrase, and filed separate libel actions on each individual phrase. Yes, obviously it costed more money for him to file these libel suits, but obviously him being somewhat richer person than Daphne was, who wasn't particularly earning an income on her journalism. Essentially, Daphne found herself having to file 19 defense pleas against each of these libel suits. And there they were. They were still all pending at the moment of her death in 2017. So I've given you two examples, one for freedom of expression and one for libel, which have shown how through sheer volume, because probably if you took the cases individually, you may have argued, if you'd like to play devil's advocate, you may have argued that there may have been some sort of merit in one lawsuit. But when you look at the volume, it becomes very clear that the strategy over here is not that of seeking justice, but of overwhelming the defendants with exorbitant costs. You're just multiplying the defense costs, the defense fees of the defendant purely for the purpose of causing harassment, of causing fear, of causing censorship. So, those are some case studies that you may wish to look up, and perhaps even if you have any questions later, we may also address them. The last slide I wish to bring to your attention is what we constitute as international best practices. So, anti-SLAPP legislation has been proposed by the EU. Now, will this be sufficiently effective? Does the proposed directive go far enough? I know already that some of you in this room already have rather diverging views on what they think about the directive and what it aims to do, and whether it's gone far enough, whether it can go further, whether any changes are needed to it. So we will discuss these certainly when we have the discussion panel at a later part of this training program today. The other question I wanted to put to the floor is whether you feel there are ways in which Maltese law can go beyond the directive. Will Maltese law go beyond the directive? Our sensation right now is that the government seems to be paying rather strict lip service to the directive, and while it hasn't come out against the directive, nor has it come out in its favor. So our guess is that if the directive had to be implemented, it would probably be implemented on its minimum basis, probably on a word for word basis from the directive, without any sort of additions or without rounding off any of the minimum standards that the directive creates. Will this happen? Will it not? Remains to be seen. But I'm gonna put a bet on my hunches being correct over here. So yes, that is all I've had prepared for you today, and I hope it's taken you on an informative journey on of the Maltese situation where we are right now. I'll open the floor up to question time, but before that, I'd like to put up on our screens, there's a QR code over there, and also a code number, which you'll see over there, which is 101051559. So essentially what you need to do is you need to point your mobile phones at that QR code. You'll be directed through to a website, and you just need to enter that reference number. You don't need to do this now. You can do this at the end of the training session, but it's important that you do, as this is a survey that has been elaborated by the European Commission, and it gives them feedback on what you think of this training and, frankly, whether it's been worth their funding. So, yeah, thank you. Let's open the floor to questions. After that, we'll go to our coffee break and then continue with the rest of our training program today. Thank you so much.